Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So, today we're going to talk about the interesting North Carolina voter ID law and the state Supreme Court's on again, off again decision about that law. So, join me down at the beach and let's talk about that. This is Jabari Holmes et al. Versus Timothy K. Moore in his official capacity as the Speaker of the North Carolina House. And it is an interesting opinion on many levels. The court starts with a review of the history. On discretionary review pursuant to the statutes from the judgment entered on September 17, 2021, by a divided three-judge panel of the Superior Court, holding that SB 824 violates the North Carolina Constitution and permanently enjoining that law, on 16 December 2022, this court affirmed that judgment, and that mandate was issued on 5 January 2023. On 3 February 2023, this court allowed a petition for rehearing pursuant to the rules of appellate procedure. And then this case was heard in March of this year. Justice Berger starts out by saying there is no legal recourse available for vindication of political interests, but this court is yet again confronted with a partisan legislative disagreement that has spilled out into the court. This court once again stands as a bulwark against that spillover so that even in the most divisive cases, we reassure the public that our state's courts follow the law, not the political winds of the day. And I don't mean to be unkind here, but you need to take that little comment with a grain of salt because I suspect we're about to see here in just a moment that perhaps the political winds did have just a tiny bit of influence in this opinion. It is well settled that the proper exercise of judicial power requires great deference to the acts of the General Assembly. That is the sacrosanct fulfillment of the people's will. And it says we're here confronted with a simple question. Does the law violate the meaningful protections set forth in Article 1, Section 19 of the North Carolina Constitution? Because it does not, we reverse and remand to the trial court for dismissal of this action with prejudice. In November of 2018, the people of North Carolina amended our Constitution to require that voters offering to vote in person shall present photographic identification before voting. The people commanded that the General Assembly enact general laws governing the requirements of such photographic identification, which may include exceptions. Senate Bill 824, now codified in Chapter 163 of our statutes, was the compliance of that, and registered voters are required to present one of a multitude of acceptable forms of ID: a driver's license, a non-operator's license, a U.S. passport, a voter identification card, a student identification card, an employee identification card issued by a state or local government, out-of-state driver's license that has provided the voter's registration was within 90 days of the election. These forms of ID are acceptable even if expired, so long as they've been expired for 1 year or less. In addition, if they lack those identifications, they can also present a military ID, a veteran's ID, a tribal enrollment card, an identification card issued by a department, agency, or entity of the U.S. or North Carolina government for a public assistance program. Registered voters over 65 may present any of the aforementioned identifications listed in A1 or 2, regardless of expiry, so long as the identification was unexpired on the date of the registered voter's 65th birthday. If a registered voter lacks one of the various types of identification, the law also requires the County Board of Elections issue without charge voter identification cards upon request to registered voters. To receive a photo ID card, a registered voter need only provide his name, date of birth, and the last 4 digits of his Social Security number. These free identification cards are valid for 10 years, which when coupled with the 1-year expiration exception, says a voter can use this free ID for a period of 11 years. The law further provides a host of exceptions. First, if a registered voter cannot produce acceptable ID, he or she may cast a provisional ballot that will be counted if registered voter brings an acceptable form of ID to the County Board of Elections no later than the end of business on the business day prior to the canvass by the County Board of Elections as provided in the statutes. In addition, a registered voter is not required to present any acceptable form of voter ID if that failure is due to a religious objection or reasonable impediment that prevents the voter from reaching or from presenting the ID. Reasonable impediments include, among other things, lack of transportation, disability, work schedules, family responsibilities, lost or stolen IDs, and other reasonable impediments which you don't even actually have to specify. Any provisional ballot cast by a registered voter who fails to present an acceptable form of ID but who nevertheless submits a reasonable impediment affidavit must be counted as a valid ballot unless the County Board of Elections has grounds to believe the affidavit is false. And there they're going to need fairly significant grounds. In sum, SB 824 permits registered voters to present a multitude of acceptable IDs, including expired IDs, and requires the state to provide free voter identification cards. Essentially, North Carolina's photo ID statute does not require that an individual present a photo ID to vote. So while it is evident that politics are playing a bit of a role here, you have to wonder how almost anyone could not get their ballot counted simply by going in and saying, look, I had to work and I couldn't get down to get my photo ID card, so that was my reasonable impediment and I want to vote. As the court points out, it does not actually prevent anyone from voting, and it doesn't even require anyone to actually have a photo ID to vote. You just have to be able to prove who you are before the end of the canvass. And that is about as benign a voter ID law as has been passed in recent years. Nevertheless, the plaintiffs filed a facial challenge to the legislation in Wake County Superior Court. And as we've talked before on this channel, a facial challenge says that on its face, in other words, without going any further, just looking at the text of the statute, it violates the Constitution. And here they said it violates it because it was enacted with discriminatory intent, it unjustifiably and significantly burdens the fundamental right to vote, creates different classes of voters who will be treated disparately, violates Article 1, Section 10 because it infringes on the right to participate in free elections, and several other. So thereafter, a panel issued a preliminary injunction and held a trial on the merits of plaintiff's equal protection claim. A majority of the three-judge panel decided in plaintiff's favor, and that it was decided that it was enacted with discriminatory intent and permanently enjoined implementation of the law. Defendants timely appealed to the Court of Appeals, but before briefing began, the Court of Appeals had to transfer the case to the Supreme Court for review. As is relevant to our consideration of this case, a separate group of plaintiffs challenged SB 824 in federal court prior to the present matter reaching this court. Plaintiffs there made nearly identical arguments asserting that the voter identification laws violated equal protection and because of enactment within discriminatory intent. On the plaintiff's motion, the district court granted an injunction because it found the plaintiffs were likely to succeed on the merits. The Fourth Circuit, in a lengthy and detailed opinion, held that this very law was not enacted with discriminatory intent and reversed the district court's decision to invalidate SB 2824 because of fundamental legal errors that permeated the district court's order. The district court improperly reversed the burden of proof and disregarded the presumption of legislative good faith. The remaining evidence in the record fails to meet the challenger's burden. On appeal to this court in the present matter, defendants argued that the panel erred in finding the law was enacted with discriminatory intent because the panel improperly reversed the burden of proof, disregarded the presumption of legislative good faith, and the defendants further contended, as indicated by the Fourth Circuit in Raymond, that the plaintiff's challenge could not be sustained under the current application of relevant legal principles. After an election that would change the composition of this court, but prior to the expiration of the terms of two outgoing justices, the majority, half of which was composed by those two justices, issued an opinion affirming the lower court's issuance of the injunction. In doing so, the majority claimed to apply federal precedent, but declined to follow the Fourth Circuit's guidance from Raymond. So just so we're clear, we have two different cases here. The state case is on top, the federal case is on the bottom. In the state court, the Superior Court found that the action violated the North Carolina Constitution, and the North Carolina Supreme Court affirmed that Superior Court finding and the injunction that was issued. Then in 2022, there was an election. Two of those judges lost their seats on the North Carolina Supreme Court. And as the rules allowed for a new motion for rehearing to be filed within the proper time, that motion was filed, and the new majority on the North Carolina Supreme Court granted the motion to rehear the case and reheard the case as if it had been brought there for the very first time. And that's the decision that we're looking at now. Down below, we have the North Carolina NAACP versus Raymond, which was the federal court case. The district court there found that it was enacted with discriminatory intent and invalidated the law. And then the Fourth Circuit reversed that opinion on appeal. Now, what you're going to see here is that the North Carolina Supreme Court looks back to the Fourth Circuit Court of Appeals decision in the Raymond case and looks at their analysis and imports that analysis into their opinion. So let's take a little bit closer look at that. Following this court's decision, defendants timely filed a petition for rehearing, arguing the majority of this court overlooked or misapprehended relevant portions of law. That motion was sustained. They now withdraw their prior decision and treat the case as before us de novo on the issue raised. Now, courts can take a number of different pathways to reach a result. They can decide the issue on the basis of evidence. They can decide the issue on the basis of some technical point of law. And a lot of times they decide issues on the basis of jurisdiction, which doesn't really have anything to do with the merits of the case. This is a case where the decision is being reversed on the basis of the standard of review of constitutional provisions. And the reason for that is because in almost every state, there is a presumption that when the legislature passes a statute, that it meets the constitutional requirements, because the legislature is presumed to be acting on the people's behalf and doing what the people wanted, and they are doing it for the right reasons, and that presumption of good faith attaches to every piece of legislation, whether that concerns how you appoint dog catchers or how you execute convicts. Whatever it is, the legislature is presumed to act in good faith and with a constitutional purpose in mind. This adherence to the principles of appellate review and the standard of review in particular with regard to constitutional provisions, that is what this opinion will most likely stand for in the future. When you review a statute, you have to presume that it's constitutional, and it can only be overcome, that constitutionality can only be overcome by showing evidence beyond a reasonable doubt that the statute is unconstitutional. And again, a lot of this has to do with the difference between a facial challenge and an applied challenge. In a facial challenge, it's just a facial challenge based on there's no way this statute can be constitutional, as opposed to an as-applied standard of review, which says, as they're applying this statute to me in my particular case, it is unconstitutional. I think they might have actually had better luck with this if they'd done an applied challenge, because then they could have brought in somebody who was, in some way prevented from voting because of the application of this specific statute. But I think the real problem is that the statute is such that it would be really hard to meet that burden, that there isn't some way he could have been accepted had he or she tried to do that. Whether a statute is constitutional is a question of law that this court reviews de novo, meaning it looks at it brand new. Under that, the court considers the matter anew and freely substitutes its own judgment for that of the lower tribunal. In exercising de novo review, we presume that laws enacted by the General Assembly are constitutional, and we will not declare a law invalid unless we determine that it is unconstitutional beyond reasonable doubt. The trial court's findings of fact are conclusive on appeal if supported by competent evidence, even if the evidence is conflicting. While a trial court's findings of fact on a question of discriminatory intent are reviewed for clear error, when a finding of fact is based on an application of an incorrect burden of proof, the finding cannot stand. Whether the court applied the correct burden of proof is a question of law subject to plenary review. Then they go into a very detailed analysis that runs for a number of pages, and we just do not have time in a video here to go through all of it, so we're going to hit the high points. First of all, as a practical matter, there must be a substantial regulation of elections if they're going to be fair and honest. It should go without saying that a state may take action to prevent election fraud without having to wait for it to occur. The Supreme Court has recognized that every voting rule imposes a burden of some sort. The burden of acquiring, possessing, and showing a free photo ID is simply not severe. The inconvenience of making a trip to a government office, gathering the required documents, and posing for a photograph surely does not qualify as a substantial burden on the right to vote, or even represent a significant increase over the usual burdens of voting, citing the Supreme Court of the United States. Here, plaintiffs have asserted that in enacting SB 824, the legislature acted, at least in part, to entrench itself by burdening the voting rights of reliably Democrat African American voters. Although the Supreme Court of the United States has required that partisan motives are not the same as racial motives, plaintiffs contend that the mere allegation that race played some part in the enactment of a law compels us to consider the effects SB 824 has on reliably Democrat voters when evaluating the intent of the legislature, and in doing so, to depart from our well-settled approach to reviewing the constitutionality of legislative acts. However, a facial challenge must fail where the statute has a plainly legitimate sweep. Under our Constitution, the power remains with the people and is exercised through the General Assembly, which functions as an arm of the electorate. An act of the people's elected representatives is thus an act of the people and is presumed valid unless it conflicts with the Constitution. From here out, the court's decision is a foregone conclusion, and basically what they say is there is no present evidence that the legislature acted with discriminatory intent, and in reaching that finding, both the district court at the federal level as well as the state court in this case forgot to think about the impact of the amendment to the Constitution that was approved by over 55% of the electorate. And that amendment basically said, give us photo ID, but make it with exceptions. And although there were lots of ways that they could hypothecate that the bill might very well offend equal protection and that some things might happen, they didn't come up with beyond a reasonable doubt proof that it was in fact unconstitutional or that it did impose burdens of any concrete sort. Now, unsurprisingly, they reversed the state court and they ordered the dismissal of the case. At the end of the opinion, however, you pick up a dissent from the court's lone dissenting justice, Justice Morgan. Let's look now at a few things that justice says about this opinion. And in the next couple of paragraphs, he throws curves at the Chief Justice for judicial activism, and he also called him out for a quote about King Louis XIV, who once famously said, "It is legal because it is my will." I will try not to do imminent harm to the French language by going through that in French. Today, 4 justices of this court adopt the same approach to the law, violating the norms of appellate review and disregarding or distorting precedent, which is what this dissenting judge is accusing the Chief Justice of doing. It is apparent from the artfully chosen words of my 3 distinguished colleagues that they have not been reticent about the notion of introducing partisan politics when they disagree. Well, it's interesting that the judge, in so doing, basically cherry picks from prior opinions where those assertions may indeed have been accurate. The judge goes on to say this majority's extraordinarily rare allowance of a petition for a hearing in this case mere weeks after this newly minted majority was positioned on the court, and mere months after this court had already decided by a previous composition, spoke volumes. All will bear in mind this sacred principle that through the will of the majority is in all cases to prevail, that will to be rightful must be reasonable, and the minority possess their equal rights, which equal law must protect, and to violate would be oppression. So the judge goes on to criticize them for not really sticking to the role of reviewing the matter properly. Nevertheless, state politics have remained racially charged, polarized going into the 21st century. That's what the court says after a review of the sort of turbulent history of black voters in North Carolina. And there's no question that they have had a turbulent history. But again, the issue here is not whether there was prior disenfranchisement of black voters, but whether this statute was passed directly to disenfranchise black voters. And that is not what the analysis that the court actually came to. They found that there was no evidence of that stood against the presumption of constitutionality. Unquestionably, North Carolina has a long history of race discrimination generally and race-based vote suppression in particular, again citing to a prior case. But again, history, the past is not always prologue. History is often history, and you can move beyond it, which is what the court in this case is saying that the North Carolina has done by pointing out, 1, that they passed a constitutional amendment that required this, and 2, by pointing out that there is not really any evidence other than speculation about what might happen if the law went into effect. He says courts are not obliged to turn a blind eye to historical circumstances, but to be fair, neither are they required to rely solely on historical circumstances, particularly when there are intervening acts of the electorate and intervening acts of the General Assembly. I thought the dissent was very well written, and I thought it made some salient points. You can't make the claim that you are standing against the whims of political oppression when what you've done is grant a motion for rehearing, which has rarely done, and then reverse a precedential opinion of the Supreme Court because you have new judges on the court, not because there's been any change in the underlying facts or circumstances. And he takes particular note of the fact that they're basing this on the standard of review while essentially at the same time perhaps ignoring elements of the standard of review. As I mentioned earlier, this is a really good example of why you don't want to make judges elected officials. Because what happens is the law seesaws back and forth with respect to issues that are of political significance. And you make the court a third political branch, which is not what it's supposed to be. Courts are supposed to say what the law is, not what the law should be. And they're not supposed to substitute their judgment for that of the legislature. They're supposed to essentially determine if something violates the Constitution under very narrow and very strict guidelines. And was the prior decision wrong? I don't know. The North Carolina Supreme Court thinks it's wrong, or I should say the current North Carolina Supreme Court thinks it's wrong. And Whether or not this decision will stand the test of time is anyone's guess. While there are good things about having judges elected, accountability for one, there are also bad things. It can do great violence to the predictability of law at the end of the day. I'm going to link the opinion in the comments, and I would love to hear your opinion of what this opinion says. Are you in favor of it? Do you think it's the right decision? If you don't think it's the right decision, tell me why. Again, I think they probably got this right on the basis of the provision of the constitutionality presumption. I think that is important. And I also think that there is almost no way that someone could be disadvantaged if you can get a free government ID, if you can even get an exception to having an ID, if you can show circumstances beyond your control, or not even circumstances beyond your control, just circumstances that you couldn't get your ID made in time. Again, it's an interesting opinion, one I think that will be cited in the future in other cases, particularly in North Carolina, on this constitutionality presumption. And again, that tracks very, very closely with the way that constitutionality is presumed in other states, particularly Missouri, where I'm most familiar with how the law operates. If you have any questions, please leave them in the comments down below. Like, share, subscribe, let people know about this. And again, today, take a few moments to do something kind for someone. Doesn't matter what it is, just do something nice. You'll feel better. Have a great day, and catch me down here at the beach tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.